In the matter of S. Mohammed Hakim versus National Insurance Company Limited, Supreme Court held the appellant liable for contributory negligence to the extent of 20%, and thus compensation payable to appellant is rupees 91 lakhs 39,253 along with the interest at the rate of 7.5% per annum from date of filing of the claim petition. Since both the offending vehicles, car as well as the bus, were insured at time of accident, liability for negligence of car driver and bus driver shall be borne by them. That is, respondent number 3 to extent of 50%, respondent number 1 to the extent of 30% respectively. Amount of compensation shall be paid to appellant within 4 weeks from date of this order. On 7th of January 2017, when appellant was riding on a motorcycle along with his friend on a piniel, respondent number 2 suddenly applied brakes of his car, which was ahead of appellant's motorcycle, and appellant dashed his motorcycle into the rear side of the car and fell on the right side of the road. The bus coming from behind drove over the appellant, which finally led to the accident, resulting in amputation of the appellant's left leg during treatment. Court said that High Court has rightly granted rupees 5 lakh for future medical expenses but erred in reducing attendant charges from rupees 18 lakhs to 5 lakhs. In present case, by taking charges of attendant as rupees 6,000 per month for 25 years, tribunal calculated attendant charges as 18 lakhs. While reducing it to 5 lakhs, High Court has not given any cogent reasons and merely noted that fixing 18 lakhs as attendant charge is exorbitant and unreasonable. Court said we are unable to understand how attendant charges of 18 lakhs fixed by the tribunal are unreasonable. The appellant has lost his entire left leg, which was amputated from waist downwards, which means that he would require assistance throughout his life to perform basic daily routine. Thus, court held that the attendant charges fixed by tribunal were justified. Under the head of loss of marital prospects, tribunal granted rupees 2.5 lakhs to appellant, and the same has been affirmed by High Court. However, in the view of Supreme Court, it is not sufficient, and in the interest of justice, it shall be increased to rupees 5 lakhs. As far as High Court's decision to grant rupees 5 lakhs for future medical expenses is concerned, Court said we do not think it requires any interference.